can't send my mom certain videos, or she can't send me certain videos. And so we leave.
Buy your mom an iPhone.
Earlier today, the Department of Justice, joined by 15 states and the District of Columbia, sued Apple in the U.S. District Court for the District of New Jersey for violating Section 2 of the Sherman Antitrust Act.
The Department of Justice, or DOJ, is suing Apple for violations under Section 2 of the Sherman Antitrust Act, and the initial words by Apple CEO Tim Cook, shown at the start of this video, might come back to haunt him, but we'll get into that later on. The antitrust law was first passed in the United States in the 1800s, and Section 2 states that no person shall monopolize any part of trade or commerce within the United States or with foreign nations. The law is trying to prevent companies from becoming too big and powerful and eliminating or significantly reducing the number of its competitors. The reason behind this is because an environment where there is reduced competition rarely ends up as beneficial to the end consumer. If that sounds confusing, then have a think about the game of Monopoly, where the winner ends up with all the property and all the cash. The antitrust law is trying to prevent this. For context, one of the biggest antitrust cases in the United States was the case against the Standard Oil Company owned by John D. Rockefeller. In this case, Standard Oil used economic threats against its competitors and secret deals with the railroads to build a monopoly in the oil business. The federal government then sued in 1911, and the Standard Oil empire was forced to be broken up into smaller groups that we now know as ExxonMobil, Chevron, and BP, for example. The DOJ does accept that it's okay for businesses to get ahead based on their merit or building a superior product. What they do not like is when a business obtains an advantage by making a competitor's product worse. Some of the items listed by the DOJ in its lawsuit against Apple is that Apple restricts the type and functionality of certain apps allowed on the iPhone. For example, Apple does not allow the use of super apps such as WeChat, and only allows its own digital wallet. So if you want to use a tap and pay functionality, you're almost forced to give your financial information to Apple when you might not really want to. Another complaint listed is that Apple charges really high fees to developers, as much as 30% of the price of any app that's downloaded, as well as any in-game purchases. The DOJ does not like that the Apple Watch is only compatible with iPhones, and the experience you get when you pair other smartwatches with the iPhone is significantly reduced. And what they especially do not like is the lack of text message functionality between Apple phones and non-Apple phones, namely the little green bubble that you would have seen at the start of this video when you receive a message from a non-Apple phone. Other comments that they make is that the pictures come through a little bit grainy, and you cannot see when the other person is typing, which is shown as 3 little dots when you're texting between Apple phone to Apple phone.
And as any iPhone user who has ever seen a green text message or received a tiny, grainy video can attest, Apple's anti-competitive conduct also includes making it more difficult for iPhone users to message with users of non-Apple products. It does this by diminishing the functionality of its own messaging app and by diminishing the functionality of third-party messaging apps.
The DOJ references the techniques used by Apple as being very similar to those used by Microsoft in the 1990s in another antitrust case. For the longest time on Windows computers, you were almost forced to use Internet Explorer, and this forced developers to develop apps for Internet Explorer as well. This was by design, where Microsoft was trying to kill off Netscape, its biggest competitor at the time. Apple's view on this is that they make innovative, inspiring products that work seamlessly together, protect people's privacy and security, and create a magical experience for its users. They're going to vigorously fight these charges. So how will this pan out? Who knows? This court case will likely take years to unfold. Let me know in the comments what you think. Do you love Apple products and how they work together? Or have you found them challenging when you try and pair them with other branded products? My name is Tomo, and I'm trying to grow my YouTube channel. So if you enjoyed this video, make sure you hit that like button. And if you want to see more from me, consider subscribing to the channel. But whatever you do, make sure you click on this next video.